Uh, we are just about done. Oh, first, I want to say hi to our friend. These are two incoming one else. Is that right? What are your names? And so, if you want to talk to them about what law school's like, they're starting here in the fall. That's not the answer I was looking for, but we're very happy to hear at South Texas, and we're thrilled for them to start. So, I hope you guys enjoyed the class. Thank you for coming. All right, we are just about done. We're really at the end. So we have class today. What comes after today? On Thursday, we will not meet here. What I'd ask you to do is use this 90-minute time to complete the fall 2018 exam part 2. Do part 1 also if you have time, but definitely do part 2. Why? Tuesday, I will go over that exam, part 2, 2018 fall in class. If you have done it, it's a meaningful class. If you haven't done it, class will be kind of a waste of time for you. So please take the time to do that. On Saturday, for those of you who can come to the Langdell session, that's with Bree. She's doing part 1 of fall of 2018. So if you have the time to do the full 3 hours, do it. All right. So again, class today. We will not be here on Thursday. I hope you use that time productively, but I can't force you. Saturday, the Langdell. Tuesday, we're here. Last day of class, going over the 2018 fall 2018 part 2 exam. Okay. Today's class, only one case. We'll fill it. Don't worry. We'll have stuff to do today. I want to go over stuff. But this is our last actually new case. So from here on out, you have no new readings. I could give you readings. I don't want to. I want you to take the old exams. Deal? Non-binding contract, but I'm happy to get the thumbs up. All right. Any questions? Anyone else see Judge Hamid's speech? I know Lynch was there. Anyone else go see it? Really, really touching. She was a female judge in Afghanistan. If you know anything about the last couple years of history, the Afghan government fell on August 15th of 2021. And immediately, if you were a female judge, you became a target of assassination for you and your family. So she fled the country to Pakistan with her young children on a land crossing. Pictures. She showed pictures of all this. It was very touching. And she had family in Texas, so through powers that be, South Texas and Texas A&M sponsored her for a visa to be a professor. So she's visiting this year in Texas. Her family's in Dallas, so she's up by Fort Worth. But she came to us to give a lecture, and that's why that thing on the board, which I don't know if you guys had a chance to come to, but it was very moving. And we think we see her studying rule of law, that good stuff. Like she was almost murdered for being a judge, right, by her own government, by her own people. She heard an explosion outside of her courthouse, and she had to go hide in her parents' house. And then she has to basically flee with her young children to Pakistan by foot, right, at a land border. If you remember the videos, people trying to get on those planes on the last few days, it was pretty dramatic. All right, Lindsay, you want to add anything? I know you were watching it also. Anything you want to add?
I mean, most of us are old, so yeah. If you just follow the history of relations in the Middle East, especially Afghanistan, even prior to 9/11 here, it's continuous at best. So hearing her story, what she had to deal with, even prior to August 15, 2021, it was a lot she had to deal with, her family too. So
And were you in Afghanistan, if I remember correctly? Yeah. Anyway, so I don't know if you get a chance to watch. Maybe I'll put the video up later, but I would encourage you to, just be aware that people are in our community, and our law school does some things right. This, I think, the thing they did right for the law school. Not everything the school does, you'll be happy with, but this one, I think the school did right by her. All right. All right. I want to begin on that happy note, right? I want to begin class by doing a little bit of a review. And I don't like to cold call in this class because it doesn't always work well. Ignore that part. But I want to walk through each of the 8 cases we've studied so far. We've studied 8 cases so far, and I want to explain why each case is relevant and what we learn from each case. The reason why is today's lesson Cedar Point Nursery doesn't cleanly follow from any case we've studied so far. And let me put this a little more bluntly, it's intention with some cases we've studied so far. So I want to recap what we've done the last couple of weeks and then go to today's case. So, Lord help me. Okay. How to check. Aaron, what's How to Check about?
How to check kind of, I want to say it affirmed.
What was it about?
How to check was about a brick factory and the town coming to the nuisance of the brick factory.
What did the town do?
They wanted to shut them down, and
What could you not do?
you could not operate a brick factory.
You couldn't bake the bricks.
Right.
Okay. What'd the court hold there?
That, put in my own words, essentially it affirmed the police power
Okay.
of saying that the government can regulate harmful or noxious uses.
That's very good.
of nuisance.
That's good. Your own words are very good words. Right. How to Check was the first case in our line. And How to Check held that the government can prohibit harmful or noxious uses. In particular, those nuisances recognized at common law. Okay, we'll see why that's important later. Right? So How to Check found no taking because this was an exercise of the state police power. Okay, and to this day, How to Check is still good law. All right, let's put another case on the board. Penn Cole. Want to do that one?
So, King Cole was the one where they were getting under the house.
Mm-hmm.
Under the house, and it was a regulation that they were trying to stop pin coal from. Essentially, there would have been I got the term, but the house would collapse.
Subsidence. Yeah.
Subsidence. Yeah. Perhaps would collapse upon each other if you dig too far. So
Good.
put the regulation in place where it would not.
Okay.
Even though the homeowners themselves, when they signed when they earned the title, they only had the title to the house.
Surface. So only surface rights. Good. All right.
They stated that the regulation was too far, and then it would constitute fate. Then they gave.
No, you're right. You're right. Keep going.
Essentially the balance.
Well, no, you were right up to what you said. Say it again. What you said.
Oh, the balancing test?
No, before the balancing test. You did the right thing.
They said it was a taking because the regulation was too far.
Good. All right. So Penn Cole is the first illustration. What we see later is a balancing test. When a regulation of land use goes too far, compensation must be paid. Why did the Penn Cole regulation go too far? Justice Holmes didn't say so in so many words, but we reasoned that there was a complete diminution in value, something close to it, right? That the value of the coal was basically wiped out. Now, to be clear, there wasn't 100% diminution in value, right? You could still have the coal, you just couldn't mine it. And you still had the right to exclude, wink, wink for today's case, right? You can still exclude people. People can trespass on your rights. If you had some sticks in the bundle, but you did not have the ability to mine the coal. So this perhaps wasn't a complete diminution in value. Maybe it was something close to it. In any event, it went too far. Well, it's important to remember about Penn Cole is what we call the denominator problem, right? Are we only looking at the portion of the coal under the house that could not be mined? Or are we also looking at all of the coal that the company owned? Justice Brandeis, in dissent in Penn Cole, said we look at what we call the parcel as a whole. All the land that's owned, what are the advantages to the law, the disadvantages to the law? Let's not just be so narrow, short-sighted to look only at the land underneath the house. Brandeis was in dissent in Penn Cole, but his view would be adopted later in Penn Central and Tahoe Sierra and some other cases. Okay, everyone get Penn Cole. All right, now we get to the next one. Penn Central. Who wants to do Penn Central? Penn Central. Yes, AJ.
Penn Central wanted to remodel the train station.
Good. Good. Good.
Or ad hoc balancing test.
Yeah, just tell us what's an ad hoc balance test? What's that?
For here, it's 3 factors they use.
Is any one factor weighing more than the other, or just whatever?
I want to say that even the didn't stand out.
Right. Yeah. So you're correct. I'll get to the DBs now. I'll come back to you. When we're talking about an ad hoc balancing test, there's no bright line rule, right? It's very fluid, and we consider context. And in particular, just as Brennan wrote in Penn Central, we look at the parcel as a whole. We don't focus entirely on the air rights that have been extinguished. We focus on the surface rights. What's going on in the train station? What about the other properties this company owns? What about these sort of transfer development rights where they can transfer the air rights elsewhere, which are potentially valuable, right? The Penn Central test was designed to say, don't have such a small denominator, right? Don't only look at what's being regulated, look at everything. Once you expand the denominator that broadly, you're going to lose, right? The Penn Central test is designed to let the government win. You are going to lose. But every one of these cases, we're arguing about, are we in Penn Central? Are we balancing, right? What you're really saying is who's going to win, who's going to lose. Now, AJ, you mentioned these three factors. Can you tell us what those factors are, please? Distinct investment-backed expectation, DIBBs. What on earth does that mean?
Government, as a government regulated as specified land use, specified development.
Good. So the core of the Penn Central analysis is we might call estoppel reliance. How much are you actually being injured by this land use regulation? If all we're talking about is some tower you plan to build and you never actually built it, then too damn bad, right? You can't say you're relying on something that doesn't exist, right? How much money have you invested to back up your expectations? Hiring an architect or a blueprint is not going to cut it. You need to do something more. So it's something of a trap, though, because you can't start building till you have a permit, and you can't get DIBBs till you have a permit. But the way to get DIBBs is to actually get the court to rule in your favor. So you're trapped. You can't actually get the distinct investment-backed expectations if the government won't let you open, break ground and start building. Everyone understand? So again, Penn Central is a balancing test designed to let the government prevail. Good. All right. Next case I'm gonna put in the list. Loretto. Yeah, Jacob.
Cable company.
Good.
Installing cable boxes, wires across all top buildings in New York City. Court ultimately held that that any permanent physical occupation is a taking and requires just compensation.
Correct. And I want to focus on word he said. Permanent. Permanent, right? Loretto distinguished between temporary invasions and permanent occupations, right? If there's something there for a short period of time, there's not a bright line rule. It's not a categorical taking. But if it's a permanent occupation, that is something's drilled into the wall, you have something bolted on the side of your building, that will be a bright line rule, categorical regulatory taking under the Loretto test. But again, I want to focus on Jacob's word, which is permanent. If you read the Cedar Point case for today, the court downplays permanence. Okay? So again, Loretto, bright line rule. Everybody wants to be in Loretto if you own property, but that's the hard one to get into. Yes, yeah, go ahead. Well, I mean, that's the rub, right? Because even if you get a taking, the just compensation was $1. So, you have all this litigation that goes on for years and years and years, and at the end you get basically $1. Right? So even though you have a categorical taking of a permanent occupation, if it's a cable about this thick, you're not getting much money for it. What's the point?
So, let's just say, on your test, you bring up taking,
I will, by the way. It's not if. I always ask about takings.
the majority, yeah. So, if you do bring up one at the cable and it's now magnified by 10, could we then attach them like Loretto and say maybe something like that could be a bigger just compensation?
There will be more, right? In other words, the magnitude of the compensation doesn't affect whether it's a taking in the first place, right? You have to. I want to, Casey. That's a good question, right? You have to separate: is there a taking? Number one, and two, what's the compensation, right? The fact that a cable is 1 inch wide or 1 mile wide doesn't go to whether there's a taking, right? It goes to what the compensation might be. Yes. Yeah.
Didn't they say what the value of the property
Potentially, yes, but that doesn't matter. Right. That doesn't affect whether in fact there's a taking. The taking is Under Loretto, you don't care about the property value. All you care about is their permanent physical occupation. All you care about. Okay, good. All right, so that's the first case, Loretto. The next case I want to add to our list is Lucas, right? Who wants to do Lucas? Yeah, and by the way, let me pause here. If you don't know these cases cold, you are not going to do well in the takings question in the exam, right? You should know the facts and holding each of these cases by memory, right? You might have an outline that's the most beautiful outline in the world, will not help you. Because the way I write my exams is questions where I'll take facts that are somewhere between Loretto and Lucas. You can't quite tell which direction you're in, right? And you figure out which test applies. Or I'll take some facts that are sort of Lucas, sort of Penn Central, sort of Tahoe, and it's not entirely clear. You have to know which one governs. Your outline will be utterly useless for these questions. You need to know these cases cold. Yeah, go ahead for the Lucas case, please.
So Lucas was the case where the guy bought beachfront property and he wanted to develop it for residential purposes, but then the law passed saying that he couldn't do that. So then he sued, saying that because his land had been 100% deprived of economic value, that it's taken.
Very good.
So the significance of it is that it introduces a new categorical test.
Good. And what's that categorical test?
Where regulation denies all economically beneficial or productive use of land that it is regulatory taking if 100% of value as well.
Perfect. Right. Lucas either introduced a new categorical test or recognized an old one. I don't really care what you think. That doesn't matter. But the Lucas test is now based on diminution in value. Specifically, if you cross a threshold, 100% diminution in value, categorical taking per se. You got to provide compensation. You see? Under Lucas, does that matter one bit? It doesn't. That would matter under Penn Central, right? And that's why he loses under Penn Central. He had zero divvies, zero. I mean, maybe some very small ones, but he didn't take any action to build. In fact, if I remember the facts correctly, Lucas wanted to let the land appreciate a bit in value. He didn't want to build right away. So he under Penn Central, he's going to lose. The Lucas test is not concerned with what could have been. Right? He could have just sat on his hands all day and not done a darn thing and still get full compensation under the Lucas test. Right? But keep in mind, Lucas was only temporary. He still kept Blackacre, right? He still kept his land. So that whatever compensation he got was for the temporary value, it was not for the full amount. All right. Oh, you were behind me. I'm sorry.
No, I'm asking this question so that we can get some clarity what's in between.
I know why you're asking these questions. You can ask them. You have another one?
No, I'll wait till you.
Okay, I'll come back. I'll maybe just wait here. No, look, the questions he's asking are exactly the right questions because drawing lines between these cases is not always easy. And I'll make this point bluntly. For my exam questions, there's not one right answer. I can accept a range of answers. So if you think it's more like Lucas, you say one thing. If you think it's more like Tahoe Sierra, you do what you think is right. And I'm going to give you points. You have to at least recognize what the various precedents are. Yes, Leah. Well, I can do this one. Oh, this is nice. Look at this. I got the expressway. Let's go. No one's here. Does anyone sit in this row? Oh, it's perfect. Yeah, go ahead.
I know that like for exams you're gonna say like common law and whatever. For the takings clause, do we ignore that and just stick to the test? Because
I will tell you, I put it this way: if there's a takings question, I will say in the question, this jurisdiction follows the Supreme Court's interpretation of the Fifth Amendment. I'll say that, and I'll tell you and that's my tell. Once I say that, there's a takings question. It'll follow the U.S. I'll say this jurisdiction follows U.S. Constitution, and you know exactly what I'm asking.
Okay.
All right, I'll walk back this way now. All right, let me go first, front. Oh, the hand or is that just hair? Okay. I used the hair, the hand. We're all good. All right, next up, I did Lucas. Who wants to do Tahoe Sierra? Who wants to do Tahoe Sierra? Someone. Someone. I'll save you for the raise. I know you like the raising case. Let Zach do the raising case. Who wants to do Tahoe Sierra? Someone. Anyone? Yeah. All right, Jay. I appreciate your volunteering. Lake Tahoe, yeah.
They wanted to develop, there were 2 moratoriums
Correct. Okay. Good. Good. And what Justice Stevens hold? What did the majority hold here? Good. All right. So what Justice Stevens did in Taos Sierra was he sort of modified Lucas. And really, think about it, what John Roberts did in Cedar was he modified Loretto. So it happens, right? Where judges modify precedents, they just don't say it. In Lucas, Justice Scalia's concern was about the diminution in value. It was with 100% diminution in value, there was a taking. You can still prohibit common law noxious uses, but 100% diminution in value is a taking. And remember, in Lucas, you couldn't build for about 2 years or so. So duration was a concern, but that didn't matter to Scalia. When you get to Taos Sierra, the court sort of pivots. They say, well, that's fine. If there's a complete diminution in value, you get compensation if it's permanent. The diminution in value must be permanent. A 3-year moratorium is not permanent. Therefore, we apply the Penn Central balancing factors. Okay. The key move in Tahoe Sierra was to revise Lucas and make the durational requirement permanent. It's going to be very rare that you have a permanent taking of that concern. You see? Well, yes. I mean, I think in that case, you had a 2-year and a 1-year more. I mean, maybe it was like 20 months and 8 months. I can't remember the exact numbers, right? At some point, does become permanent, right? So I think what you'd say is, I'm just making this up. Let's say, I say the jurisdiction had 3 consecutive 10-year moratorium, and we're at year 30, and they're saying, oh no, it's still temporary, right? I think even at some point, Justice Stevens say, okay, you guys went too far, right? That's now, and look, he might even say, you know what, under Penn Central, this is too much, this goes too far, right? I think Stevens would say, we just do Penn Central and you win under Penn Central. If you're legit saying 30 years you can't build, at some point the economic impact is so great that you basically didn't take in your property. I listened to the oral argument in this case in Taos Sierra, and John Roberts was a lawyer, and I think Chief Justice Rank was asked that question, would 30 years be too much? And Roberts like, well, yeah, that's probably too long. So even Roberts in private practice thought 30 years was too much. So what do I know? All right, everyone get Taos Sierra. All right, next case is Kuntz. Who wants to do Kuntz? Just from class last week. Thank you very much for volunteering. Nah, we'll be nice here.
So basically, Kuntz owned a permit to the wetlands behind his property,
Mhm.
and he wanted to, he submitted permits to
Good.
the property, and he said, I'll give you easement. They said no, unless you help develop land miles from your property.
Good. And by develop property, what do they require him to actually do?
To build
And who would do that work?
the city,
And who would pay for it?
him.
He would pay for it. That's the important point. The government said you have to pay for these restorations of the wetlands. All right, go ahead, please.
Oh, and then they applied Nolan and Dolan. In the Nolan case, the government wanted to get an easement for the permit, and because they can't export the government. The government can't export a person for a permit. And then in Dolan, he wanted to expand into the parking lot land, and that's where the next test came to this.
Excellent. Thank you very much. All right, so there's a lot going on here. Kuntz, I think, is a complicated case because it's based on this other doctrine called exactions. Right? What's exactions? An exaction is when the government puts a condition on a permit. They say, okay, you want a permit? Let's play ball, right? You scratch our back, we'll scratch yours. So the classic example happened in Nolan, where a guy wanted a permit to renovate his bungalow on the beachfront property. And the government said, okay, that's fine. We'll give you a permit, but you have to give us an easement. You have to dedicate an easement to the public so that the people of the city can cross over your land to get to the beach. Now, what on earth does having a building permit have to do with a beach easement? The government said, well, if you build this house, people may think that the beach is not open to the public and they won't want to use the water. So we need this easement to reassure the public that there's easy access to the beach. I don't think anyone finds that persuasive. I don't. Seems kind of stretched. And what the court said is you don't have enough of a link, a connection, a nexus, if you will, between the benefit being sought, the permit, and the condition, which was the easement, right? The nexus wasn't strong enough. This is what's known as the unconstitutional conditions doctrine, that the government cannot condition some benefit on surrendering a constitutional right. You have a constitutional right to not have your property taken. The government can't take your property because you need a permit out of it, right? That's basically, to use Talia's word, extortion, right? You're extorting that benefit from the property owner. Dolan was a similar story, right? Here you had a guy who wanted to pave his parking lot. And the government said, okay, you want to pave your parking lot? That's nice. We want you to dedicate this huge green space to us a few blocks away by a creek. And the court said, whoa, that's out of whack, right? All he wants to do is pave his parking lot. You can't demand this ginormous green space easement. It's not proportional, right? That the remedy sought is out of whack with the actual benefit of the paved parking lot, right? So you have these two tests, substantial nexus and rough proportionality, with the unconstitutional conditions doctrine. It has to be a close enough fit between what the government's asking for and what the person wants. Now, Kuntz was sort of neither here nor there, right? It followed Nolan Dolan, sort of. Kuntz involved the payment of money. But to be candid, no actual property was taken because he never actually gave an easement, never actually paid. So Kagan says, what are we even talking about? Where's the appropriation? Where's the taking? Sound familiar? In the case today, Breyer sounds a similar tone. Like, they didn't take anything. What are we even doing here? So what we've seen, at least in Kuntz and in Cedar Point today, is the dissenters like, what the hell's going on? There's no actual taking of property. Why are we doing this? What's going on? And we'll talk about this more today. Questions on Kuntz or Nolan and Dolan? You need to know all three cases, so put this on your list. Zach, it's your time. You were born for this. Let's go.
So corn is a grower of raisins based out of California. The government is part of I'm going to call it a price fixing scheme. That's not what they would call it. But the government is part of the price fixing scheme. Decided that
How about trying to stabilize a price of crops? How about that?
That's a better word.
Go ahead. All right, go on.
It's trying to stabilize the price of raisins. And so it's taking raisins and selling them at prices that it sets, and then returning the proceeds to the farmer minus fees and taxes. Horn has grown weary of this scheme, and when they come to pick up his raisins, he simply says, no, you can't have them. He turns their trucks away.
Mm-hmm. Does he shoot their tires?
He did not shoot their
Okay,
tires.
just making sure.
To my disappointment.
Okay.
He was then fined by the Department of Agriculture.
Because you shot the tires, the trucks couldn't leave, so that would probably not be the best idea. Go on.
He's fined by the Department of
These
Agriculture.
401ls, and you're like, they're just, what is this? What is this class? Don't take Blackman, right? That's what they're thinking. Go on.
Right. So he's fined by the Department of Agriculture for what they assess to be the value of the raisins, plus a civil penalty
Correct.
of, I think, 200 grand.
Correct.
Okay.
Yeah.
And he takes them to court saying that the takings clause prohibits them from simply taking his raisins and then giving him back the amount that they feel he deserves for them.
Okay, good. What was the test, or in other words, which one of these precedents, which test was perhaps most relevant to Horn?
Horn played, if I recall correctly, off of Lucas and Loretto,
Well, explain what you mean.
in that it was about a permanent occupation of property. Granted, it was private property.
So let's just tease this out. In Lucas, did the government actually physically appropriate any property?
That's not great in Lucas. No.
He says no. He's correct. Okay. In Loretto, did the government physically appropriate property?
I'm going to say yes.
Yeah, they drilled a hole in the wall. All right, that's enough.
We'll call it
Okay. So which case was Horn closer to, Loretto or
much
Lucas?
closer.
Good. And Loretto was balancing or categorical?
Categorically.
Okay, good. So in Horn, again, it was a Roberts opinion, so don't expect it to be very clear. The Chief Justice explains that this is very similar to Loretto, right? That physically seizing raisins is a physical appropriation. You're taking the raisins away, putting in their hands, putting in their trucks, driving away. And once you get to Horn, you have to use a bright line. I'm sorry, Loretto used a bright line balance, a bright line test where you don't consider anything. All you consider is was the raisins taken. The only question is what's the compensation. Here, the majority in dissent disagreed. The dissent said, well, you get these proceeds from the sale of the raisins. That's enough for compensation, maybe. Majority said this is ridiculous. The government already priced the raisins at $400,000. That's your compensation, which by the way was the exact amount they owed to the government, so just wiped out the debt. So basically nothing happened. All that case was for many years was just to wipe out the penalty and the fine. Okay. Questions on Horn? All right, so I count about 8 cases or 10, depending how you want to count them. You need to know these cases cold. I always ask about takings, maybe 1 or 2 questions, and you'll just need to know these. Today's case will throw things out of whack a bit, and I'll try to hopefully make sense of it. I don't know if I'll succeed, but I'll try. What?
Not like you're not out of whack already.
Look, this was a hard class to teach before 2021. I'll just cut to the chase. I wrote this blog post the day that Cedar Point was decided, and you can just read the headline. Cedar Point Nursery Hassid quietly rewrote 4 decades of taking Flow's doctrine. You're welcome. So I was probably the first person to make this point. I've been cited for a number of times, but this case really shifted things around in ways that are not obvious. So for those of you who are trying to keep your lovely flow chart, it's just going to go off the rails today. Sorry. Okay, so let me take another step back. Did you study in Property 1 2 cases about the right to exclude? Jacques v. Steenberg Homes and State v. Shack. The trailer home, the trailer driving through the snow, the migrant workers. With the snow, remember you had to drive through the snow? Yes. Correct. Did you study these, or just your memory's a little fuzzy? Yeah. All right. Let me refresh your memory. So way back, like 4 months ago in Property 1, I know Cooland or who, right? You study the right to exclude. Yes. And we say that in the bundle of sticks, in the bundle of rights, the most essential stick is the right to exclude, right? That's the basic one, the most important. And the case book has 2 cases. I promise you they're in there. One called Jacques v. Steenberg Homes from Wisconsin. The second one's called State v. Shack from our lovely state of New Jersey. I guess from New Jersey? No? Okay, I'll be making from New Jersey soon. Okay. I'm from Staten Island. I have immunity. So what was Jacques v. Steenberg Homes about? So you had a company that delivered mobile homes. Don't call them trailer parks, right? Mobile homes are these very wide buildings, right? And how do you transport them? You put them in the back of a flatbed and you drive them. This was in Wisconsin in the winter, as you might imagine. There was a lot of snow, and the road was basically impassable, right? You couldn't take this wide load on the road because you would tip over, injuring perhaps the people driving it, maybe even break the trailer. The only way, probably the only way to deliver it right away was to basically cross this one farmer's land. Now, you could wait till the spring, of course, right, when all the snow melted, but that would have made it inconvenience to the person who bought their trailer. They wanted their home. And this is someone's house, right? I don't want to just make this trivial. People living in mobile homes are not always the wealthiest people. This was actually their home they bought. This is where they want to live. And so every day you're not delivering this thing, someone else is not living in their house. So I want to just table that because the equities here aren't always as you might think. So the manager of the mobile home company said to the owner of the farm, Jacques, hey, can we cross your land? There was like feet of snow. They would have made no damage, maybe some tire marks in the snow, but no actual damage. Property owner said, no. Completely unreasonably or reasonable? You tell me. I don't care, right? But the answer was no, you cannot cross. So then the manager said, all right, screw this. And he told his guys to just drive across the field and deal with it. What happened? They brought a suit for criminal trespass, right? Trespassing on the land. And the jury awarded basically nominal damage. I think it was $1 in damages for compensatory, and then a substantial worth of punitive damages. And the question on appeal is, was the punitive damage award justified? And the court said, yes, it was, right? That the right to exclude is very important, that property is yours and you have the right to keep out whoever you want, right? There's a very pro-property decision. And maybe you agreed with this case, maybe you didn't, maybe you really were not sure. But the very next case in the book is called State v. Shack. It's from New Jersey, so you know what's going to happen. They're going to do something crazy, right? It happens every. See, I told you, it happens every single case. So what was this case about? Casey, your hand up. Okay, I do that sometimes. Make you scratch your head. State v. Shack was our next case. What happened? You had a farm in New Jersey, and the farm was run by a farmer who didn't treat his workers very well, not at all. These were migrant workers, some called seasonal workers, who basically go from farm to farm, depending on which crop was in season, and would harvest them. The farmers lived on the property. The conditions were dirty. They were cramped. They didn't have running water. These people were poor. They were illiterate. They didn't have anything. They were living at the mercy of the farmers. And the farmers would control them, saying that if they left the farm, they'd be fired, right? They'd lose their job. And so they couldn't actually leave the farm without losing their livelihood. And they were paid very low wages. So then you had these two workers who worked for his aid groups who went to the farms to try to provide services. So one was giving legal aid to the migrant workers, and the other one had medical training. He was removing sutures from the guy's hand because he had cut his hand on some equipment. All right. What did the farmer do when he saw these aid workers come on board? He called the cops. And this was a setup, by the way, right? These guys wanted to get arrested. They wrote a reporter with them, right? They wanted to get arrested. And they got arrested because the farmer pressed charges. And the case goes to the New Jersey Supreme Court. Sort of a weird case because no one actually wanted the case here. The prosecutor wasn't litigating the case. And the court says, okay, we have a trespass statute. The right to exclude is real important, but other values are more important. We have human rights, human values, the right to give aid to these people. And basically, New Jersey carved out an exception to its trespass statute to help migrant workers. It's New Jersey. That's what they do, right? You knew this was going to happen. So you have these two cases about the right to exclude, right? And then we get to today's reading, Cedar Point Nursery in California. And in many ways, Cedar Point is a reversal of State v. Shack. Not exactly, because State v. Shack was a state common law decision, whereas Cedar Point is a federal common law decision, but they are in tension. Did anyone want to give me the facts in Cedar Point? Go ahead, sir.
So Cedar Point, there's a California regulation that was required agricultural employers to allow union organizers onto their land for, in some total, 3 hours a day for 120 days. 1 hour before work, 1 hour at lunch, 1 hour after work.
Good.
They don't disrupt the process or anything like that.
Good.
But there was some pet thing that they had to file formal notice with the board and serve that copy to the agricultural employer. On October 2015, the United Farm Workers, they at 5 a.m. went to the farm.
Crack of dawn, right?
Didn't provide notice.
Nope.
Nice ruckus.
They were bringing the bullhorns.
They basically broke all the rules that was set in place.
Yeah.
Cedar Point filed suit. Responded.
And just what remedy was Cedar Point seeking? Were they seeking just compensation?
So didn't they get rid of this law in the first place?
But what remedy were they seeking from the trial court? Yes, very good. They were seeking an injunction, which is kind of weird. Because in every single takings case we saw so far, the remedy sought was damages, just compensation, money. They didn't actually want damages. Because I think the union guys said, sure, we'll let the government pay to let us onto the property. Sure, no problem, right? This money wasn't going to come out of the hands of the union workers, right? This money would come out of the taxpayer dollars. Yeah, sure, whatever. Pay them to come on board. They wanted an injunction to block the workers from coming onto their property. That was their goal. All right, keep going.
So the district court held that it was they rejected the argument that it was a taking, a first rate taking, and I think it was 2 grounds. So they said there wasn't a permanent and continuous access to their land
Mhm.
because there was a set amount of time they were allowed to be on there. Then they also evaluated under the Penn Central balance test and found that it didn't satisfy.
Okay. No, because you're gonna lose, right? You're gonna lose anyway. Thank you. Very good for that. All right. So let's just sort of think of this objectively, right? Let's say that you were a law clerk for the trial judge, and this case comes to you, and you paid really good attention to property, and you took this little list of cases with you when you sat for the bar, and you have this in your notes. You say, "Okay, judge, let's walk down our list of cases, right? What case we used to analyze this? Well, is this had a check? Not really. There's not really any common law nuisance, right? People organizing labor, that's not really a nuisance. Is this like Penn coal? Well, no. I mean, look, does this regulation go too far? The farmers can still farm, right? They have all the value of their crops. Maybe for a couple hours a day they have a disruption from having these people come on board, but they're still managing their operations. They're still getting profits. There's not really much of a diminution in value. Because they say, is this Loretto? I'm sorry, is this Penn Central? And you might say, well, look, let's think parcel as the whole. You have 365 days of the year, and here we have only 120 days of the year for a couple hours a day. Parcel as a whole, you got yourself just fine the other 240 days of the year, right? What are you complaining about, right? Okay, then we ask Loretto. But wait a minute. I remember Professor Blackman said Loretto is when you have a hammer and a nail, right? Is there a physical installation? Did you drill something in? Is this permanent? No, it's not permanent. These guys come on for an hour and they go home. And they come on for an hour and they go home, right? They're not there permanently. They're literally temporarily for a couple hours at a time. Then you might say, okay, what about Josh? What about Lucas, right? Is this a Lucas case? Anyway, okay, so complete diminution in value. No, there's still value to the farm. They're still generating revenue. Just for a couple hours or a few times a year, they can't do this. Okay, Tau Sierra, no, this absolutely it's temporary. All right, what about Kuntz and Nolan and Dolan? Right? Is this a condition on having their property? And that might be closer, right? I think that might be the closer test because you say, well, if you want to operate a farm, you must surrender. You must provide access to these workers, these union organizers. That's probably the closest one you have there. But in terms of substantial nexus, you're employing farm workers. It would seem relevant whether your farm workers are being treated right, and maybe these union officials can determine that. That probably passes substantial nexus test. I don't know. Maybe not. Maybe yes. And you're not giving away an easement. You're just allowing them on temporarily. I keep saying temporarily. Notice I keep saying that, right? And corn, have you seized anything? Is there any seizure of property? So no. So if I was a law clerk, looking at this case, I'd maybe apply Penn Central, maybe I apply the Nolan Dolan framework. I'm not sure exactly which case, but government's going to win, right? Under the case law that existed before 2021. All right, but then the court doesn't do that. The property owner wins. How do they win? Anyone want to tell me what the court did here? It's the John Roberts special. That's what I call it. So when the chief looks like he's being really neutral and calm, and he just sort of changes the law under your feet. He's very good at that. He was always a good advocate. He still is. If I got to judge things down, but he's a very good advocate. Anyone want to tell me? What did Roberts do here? Zach.
Basically, he applied Loretto to it.
He applied Loretto. Wait a minute. Zach, help me out here. Didn't Loretto say, we said this a few minutes ago, permanent occupation, permanent. We said that word a million times. And then what did Roberts do to that?
Yeah, you're not allowed.
Do that without the double negative. I know. Yeah.
The fact that it's a mandate to allow these people onto your property in effect makes it permanent despite it not being informed formally.
Good. All right. I think Zach got it, right? When we use the word permanent, what does permanent mean? Well, you might think permanent means 24 hours a day, 7 days a week. That you have a cable on your wall 24 hours a day, 7 days a week. That's how I understood permanent for the last decade teaching this topic. But what do I know, right? The court defines permanent differently, right? What's permanent is not the number of hours that the workers are on the farm. What's permanent is the right of access, that there's permanently a right of access under the statute, and that the statute will endure forever. Everyone see that? There's permanently a right to access, even the right of access. So, I mean, let me defend the chief for a moment. Let's say the government said, okay, you can cross the beach anytime you want during daylight hours, right? You can't cross at night. You can cross during daytime. 365 days a year, but only during daylight hours. Is that permanent? Well, in one sense, no, because you can't cross it at night. You have the night to yourself. In the other sense, it's a permanent right of access. And that's what the court sort of does. Yes.
I'm gonna say, I like the rule.
You like it? Good. I like it. By the way, I agree with this case. I like it, but just, I want to be very clear how the court sort of modified doctrine. That's what I'm trying to get at with you all.
Because I feel like it was a lot more straightforward than the other 9 cases that we had, which is essentially.
Oh, this is easy. Yeah.
If the government says that you have to let someone on there, you can't exclude them, which is the right to exclude someone from your property, then you should be compensated. Now, after that, it's the compensation that comes. What is just compensation? That's when you start moving. If that 3 hours a day or 120 days a week or 120 days a year is enough to get substantial payment for it, which is the same thing that happened with Loretta as well. But you are taking a part of their property because you're forcing them to allow people on their property.
Well, let me just come back to you if I can, because you raise your hand, right? What does it mean to take in this context? Is there any physical any physical property taken away, like the raisins?
No, it's not physical take, but it is I would say the taking is
The-
the
or
right to use your land how you want to.
Well, isn't that Tahoe Sierra that they took away the right to use the land for 3 years?
Yeah, that's why it was stupid.
Well, I know you don't like that one. Aaron, what do you think?
I think I like the ruling too, but
Okay.
it seems like the right to exclude is the most fundamental property right.
So is this ruling limited to the right to exclude? Let me change the hypo, right? In Lucas, in Tahoe Sierra, you couldn't build for 3 years. Building your land's pretty important, right? Generally, people buy land to build on it, right? Maybe next to the right to exclude, the right to build has got to be up there, top 3 or top 5. Is Tahoe Sierra overruled here? Because in other words, if the government prevents you from building, and that's an essential stick in the bundle, isn't that a taking also?
Yeah, it's the temporal aspect of this.
But this was
ruling.
temporary too. It's only 3 days, 3 hours a day to 120 days a year, right?
But
But the moratorium goes on for 3 years.
the moratorium does go on for 3 years, but there's a state statute that says that this is just happening on your land.
Mhm.
Once they give you notice, whether you like it or not, once they give you notice, you don't have the right to escape.
I saw your hand went up.
Well, I was gonna go back to like, concept with the building part, it was considered temporary, like, after those 3 years, you'd be able to do whatever you wanted. With this, like, saying that you can't.
Permanent.
Yeah, it's more permanent because although it's like a temporary part of your day or whatever, you can't, it's not like there's any part where you can just.
So
like,
it's
do
not
something permanently to it.
so it's not a permanent diminution in value. It's a permanent blank. Fill in the blank. What's permanent? Actually describe it. What's permanent? He says permanent. What's it?
It's permanent the way that you.
But what's it? He said it's permanent. What's it?
The way that you can use your land.
So anytime the government says how you can use your land, think of the air rights above Penn Central, right? Why is that not permanent? Why is that not a permanent appropriation of your air rights?
Well, I mean, I would think that ground rights are a little bit more,
Well,
well,
sure.
like using the ground that you build on, and for example, like how we were saying with the Tahoe case, and that one 3 years, okay, after that you could build.
Okay.
On this, if you wanted to build on that land or whatever, but you can't because you have to allow people
Mhm.
to go through that
Mhm.
land. It doesn't matter how often or what the schedule is for when they do it. You can never build on there even if you wanted to because you have to allow.
For those 3 hours.
Yeah.
All right. Anyone else want to add anything? All right. Let me give you another way of thinking about this one, right? let's say the government came out and said, hey, we want an easement across your property, right? No permit. We just want an easement. They'd have to pay compensation for it, right? That's pay just compensation. Everyone agree with that? So what Robert says in this case is functionally what the government did was they extracted an easement from the farmers that you must allow these union workers on your land 3 hours a day for 120 days, whatever it is. So in effect, this is an easement. Justice Breyer is so cute. He's like, well, it's an easement and gross, who's benefiting from it? And Robert's like, I don't care, right? But is this actually an easement, right? Sort of, right? But it's still going back to the question of you are diminishing your right to exclude. All right. So what's the holding of the case? If I had to actually, summarize the holding of this case, what's the holding of this case? When the government takes your right to exclude, that's a appropriation, a physical appropriation. I say it again. When the government takes your right to exclude away, it's a physical appropriation. And that requires compensation. Now, let me just pause for a minute. Is the right to exclude an actual thing? Like, can I hold that in my hand like a raisin? No, it's sort of like a legal construct, it's a legal idea. But Roberts elevates the right to exclude to an actual physical interest, which is how we get to Loretto. Right? I think Zach said a minute ago, the closest case for the court is Loretto. That's really the case we're relying because you have a categorical rule. And Roberts analogizes allowing the workers on 3 days a week, 3 hours a day, with taking the drill into the wall and taking the cables in the wall, right? Now, I want to just focus on a couple portions of the court's opinion, if I can, right? And so this I think is probably the most important paragraph of the opinion, which maybe you disagree, but I think it's quite important. Roberts says, whenever regulation results in a physical appropriation of property, again, keeps using this word physical appropriation. Appropriation, what does that mean? It means taking. It's a synonym for taking, right? You take. Whenever regulation results in a physical appropriation of property, a per se taking has occurred, and Penn Central has no place. The upshot of this line of precedent is that government authorized invasions of property are physical takings requiring just compensation. Like, wait. Didn't we learn that temporary invasions are not takings? Categorical. Isn't that what I'm not making that's your notes, right? The court said if there's a temporary invasion, that is not a categorical taking. That's what Marshall wrote. Very next sentence, Robert says, the duration of an appropriation, just like the size of an appropriation, bears only on the amount of compensation. Whoa. Isn't the entire point of Loretto focusing on the duration of the appropriation? Wasn't the entire point that the cables be there forever? I mean, Roberts is washing over about 4 decades of precedent. Just whoosh, right? And I like this case. I agree with the outcome implicitly, but I cannot stand it. What should they do? Overrule Penn Central. My goodness, it's much easier, right? But they can't overrule that precedent. They have to just make all these caveats and carve outs to Penn Central. I mean, that's what happened to Scalia and Lucas, right? Scalia would have overruled Penn Central if he had the votes. He did not have the votes. So he created these exceptions for the common law and for the diminution of value, just sort of made it up around. It's like you're basically crafting all these epicycles around a terrible precedent. You can't get rid of the original core. And then Roberts says, to begin with, we have held that a physical appropriation is a taking, whether it's permanent or temporary. Well, that's true if we're talking about raisins, right? If you physically take the raisins. But in Loretto, there was no actual physical removal of the property. They were just installing something. And in that case, the duration did matter. So where does this leave us, right? How do we reconcile Loretto, Penn Central, Cedar Point, right? You have this nice, beautiful list of cases, and I'll just write Cedar Point on the bottom. Where does Cedar Point fit? And I don't have a perfect answer for you. And it's not because I didn't prepare for class. It's because there is no good answer, right? This is a new case. It's about a year old. I guess about 2 years old at this point. And we don't have much guidance. So I think I would at least say with the Cedar Point case, when you extinguish the right to exclude, that is a physical appropriation. Again, when you extinguish the right to exclude, that's a physical appropriation. And under the precedent, when there's a physical appropriation, there's a categorical taking. Categorical taking. The duration does not matter. Again, when you have a extinguishment of the right to exclude, you have a physical appropriation. And when you have physical appropriation, the duration does not matter. No, you also don't care about diminution of value. It doesn't matter. We don't ask, is there 100% diminution of value? That doesn't matter. We don't ask, is there a distinct investment-backed expectations? Does not matter. We don't ask, what's the economic impact? We don't care. We don't ask, what are the reciprocity advantages, right? The parcel of the whole, we don't care. So this right to exclude is sort of elevated above all else. So where we are now is that we have Loretto and we have Cedar Point. Those are our two categorical tests. And with both categorical tests, when there's a right to exclude or a permanent physical occupation, those both categorical takings requiring just compensation. Does that make sense? I don't think it does, but maybe you do. I don't know. I'm doing the best I can. All right. Questions in the majority by Chief Justice Roberts. No? All right. The dissent by Justice Breyer is kind of confused, right? He's like, what's going on here, right? Why are we saying that removing the right to exclude is a taking, right? Is an appropriation. The regulation doesn't appropriate anything, right? It regulates the right to exclude, but it doesn't take it. And at most, this is a temporary invasion of property. And how do we evaluate temporary invasions? Penn Central. And under Penn Central, there's no argument that the farmers win, right? The government wins here under Penn Central easily. Right, so we have the same sort of refrain. Let's apply Penn Central. Let the government prevail. Okay, but again, Roberts, Breyer says there's no easement granted. Right, this is not permanent. This is regulating use. It's not actually granting an easement. Okay. Questions on the dissent? Questions on the dissent? Do you guys have questions? No? Okay. Yes, ma'am. By the way, my favorite question as law professor begins on the exam. That's just my favorite. I love those questions. These guys know it. Go ahead.
So,
Yeah, get to the point.
Dan, you can set down, analyze, and take it, concluding that's gonna be on there, right? Do you care? Because it's only 500 words per essay, right?
Well, it's 1,000 words, and then you have 5 parts. It's actually 200 words per question.
Right. So in reality, we shouldn't care. I mean, we don't really have to say much about the dissents on some of these, or what if we agreed with some of the dissents? Because that's
I
considered
think
law.
the dissent might be relevant for a policy question, but to be candid on questions 1 through 4, the dissent's not going to get you very far.
But part 5 is good.
Probably, I think. Yes, sir. Oh, I like my little highway over here. Go ahead. When do you learn about a justice's view outside of a case?
What are you like? Let's say we're talking about just Thomas. We're talking about like the parking lot and the thing getting unfair. We're balancing it, but we don't find the case. We could think of it and say this is his idea.
I probably want to ask what Justice Thomas thinks. That's not a question I would ask. Not in this class, at least.
No, I'm just saying like if we're not necessarily just him.
But why? I don't understand. Why would you care about Thomas versus a case the court decided?
No, if I can't remember the case, I'm asking the balancing of.
I wouldn't do that. Yeah, we didn't really talk about. I mean, we talked about Thomas and Kilo, for example, but I'm not sure that gets you very far. Remember the cases. That's the answer. Yes, AJ.
So with this one earlier, you mentioned it kind of might match up with Kuntz. We talk about that a little bit.
I'm sorry. Say that again, please.
Did you say it kind of matches up with Kuntz?
Econa? What word are you saying?
It kind of.
Oh, it kind of. Oh, Cedar Point. Well, if I was a lower court judge, and in fact they did, I think Kuntz might be relevant as a lower court opinion. But I'm not sure that that's what the Supreme Court did. Okay. Other questions on Cedar Point? All right. Yes, ma'am.
I know you said it doesn't fit into like one, like, section or whatever, but like just looking at the question, it goes like from the physical occupation, just talk about both and just whatever facts apply.
Both Loretto and Cedar Point?
Yeah.
But again, Cedar
I know
Point
how
doesn't
this-
require permanence, so they're not the same. And really, the word appropriation when you see occupation Loretto, they're drilling a hole in the wall. That's the occupation. Here, there's no occupation. You have people coming and going.
Okay.
What else? Questions? All right. Going once. Going twice. All right. I'll turn on the exit poll. Please put in your answer. You have a little bit of a break tonight. I will see you all not tomorrow, but on Tuesday. All right. Have a good night.